Arrest warrants have already been signed.
Charges for 2 Atlanta police officers involved in the fatal shooting of a black man in a Wendy's parking lot. One accused of felony murder.
Officer Rolfe actually kicked Mr. Brooks while he laid on the ground.
The other accused of aggravated assault.
Officer Brosnan actually stood on Mr. Brooks's shoulders.
Conflicting stories if Officer Brosnan is now a cooperating witness. Plus, the widow of Rayshard Brooks reacts.
It hurt. It hurt really bad.
And Atlanta police reporting calling out sick in numbers. What this means for the department right now on Law&Crime Special Report, Keeping the Peace. It's Thursday, June 18th, 2020. Well, welcome back to the Law&Crime Network, a special report, Keeping the Peace. On June 18th, 2020, we have major developments in the Rayshard Brooks case. One of them being the district attorney has announced charges on both officers. With respect to former Officer Rolfe, it's felony murder, the highest charge, aggravated assault, violations of oath of office, and for Devin Brosnan, aggravated assault and 2 counts of violation of an oath for office. And some compelling information from the district attorney with regard to how far away the officer was when the shots were fired. Let's take a listen to the district attorney.
Once Mr. Brooks was shot, there is an Atlanta policy that requires that the officers have to provide timely medical attention to Mr. Brooks or to anyone who is injured. But after Mr. Brooks was shot, for some period of 2 minutes and 12 seconds, there was no medical attention applied to Mr. Brooks. But when we examined the videotape and in our discussions with witnesses, what we discovered is during the 2 minutes and 12 seconds that Officer Rolfe actually kicked Mr. Brooks while he laid on the ground, while he was there fighting for his life. Secondly, from the videotape, we were able to see that the other officer, Officer Brosnan, actually stood on Mr. Brooks's shoulders while he was there struggling for his life. We were able to conclude that based on the way that these officers conducted themselves while Mr. Brooks was lying there, that the demeanor of the officers immediately after the shooting did not reflect any fear or danger of Mr. Brooks, but their actions really reflected other kinds of emotions.
Okay, so there's a district attorney. Listen, in this episode, we're going to talk about both sides of the coin here because now these police officers are charged as criminal defendants. And regardless of what your feelings are about this case, they are entitled now to certain rights that every criminal defendant is, including proof beyond a reasonable doubt, to 12 jurors, the right to remain silent, and all the other protections that any other defendant would get. Couldn't have a better guest than Lisa Lockwood with me. She is a crime analyst, a media contributor, an author, a law enforcement expert. Thanks for coming on the show, Lisa.
Thank you, Bob. Happy to be here to help.
So what are your thoughts about what the district attorney said? But moreover, and I think people kind of lose sight of this when they get very charged about this, and I understand why. Now, as a criminal defense attorney, having been a former prosecutor that prosecuted police, I defend cases. And the bottom line is now I have to make sure in this case that my client is properly represented. We're going to get to that a little bit later. But overall, what are your thoughts about this case so far?
Well, they acted far more swiftly than they did in the George Floyd case. And I think the expectation was that there is video footage. And once that video footage was analyzed and the GBI was able to investigate the case, they felt that there was enough to go ahead and charge these officers with these particular crimes. Again, one thing that the concern that I have is because it was so swift, is the charging correct? And we're going to find out if that charging is actually correct from everything that the public has seen up until this point and also the Georgia Bureau of Investigations.
You know, Lisa, you bring out an amazing point. And when I had police-related fatality shootings when I was prosecutor, I had a very strong community affairs outreach. I would bring the minority community leaders in, and I say, please, you know, steady pace wins the race. Let me do this investigation from beginning to end, completely appropriate for no other reason that a defense lawyer down the road can't say, this was a rush to judgment because they were catering to the court of public opinion, both with respect to the investigation and, as you point out, the actual charges filed.
That's correct. And in light of the situation that we're in right now as a country with these prior cases, people want an immediate response. They want action taken right away. And what the feedback right now with the public is like, we don't care that they're even arrested right now. We want to make sure that these officers are convicted and it is a fair trial. So they want to make sure the arrest means nothing. They feel right now that it's a placating move, so to speak. So things can change as far as charges as the court proceeding goes further, but I think at least part of them feels as if that at least it was done a little bit more swifter than the George Floyd case.
You have very delicate balance for prosecutors because you also are working with the police on cases which sometimes causes problems and sometimes doesn't. Let's take a look at a tweet, though, about if they feel like they're being rushed and they're not being held are being held accountable unfairly. Earlier suggestions that multiple officers from each zone had walked off their job were inaccurate. The department is experiencing higher than unusual number of callouts. With the with the incoming shift, we have enough resources to maintain operations and remain able to respond to incidents. So you're going to see, I am sure, a lot of pushback with regard to this case, whether these things are true or they're not. Also, the district attorney talks about what is being referred to, and so our audience understands, under our evidence rules, an excited utterance. An excited utterance is an exception to the hearsay rules. Typically, hearsay is not admissible in a courtroom, but if you say something in the spur of the moment, it may be admitted against you at trial. Let's take a listen.
We have concluded that Mr. Brooks was running away at the time that the shot was fired. Mr. Brooks was shot twice in the back. One of the shots was a center shot to the back that penetrated his heart, and it was done by a 9mm Glock. Now, one of the things that we also relied upon in our conclusion is something that is called under the law or referred to as an excited utterance. And that's when someone makes an immediate statement, and because it is made without the ability to consult with counsel or to think about it, under the law, an excited utterance is considered as highly reliable. And at the time that the shot was fired, the utterance made by Officer Rolfe was, "I got him." That was the statement that was made at that time. We also noted that Officer Rolfe was firing a taser at Mr. Brooks. The City of Atlanta SOPs, in fact, prohibit officers from firing tasers at someone who is running away. So the City of Atlanta says you cannot even fire a taser at someone who's running away, so you certainly can't fire a gun, a handgun, at someone who is running away.
Lisa, in order to have fairness here, I want to bring out something that the defense attorney said in rebuttal to what the prosecutor said there, because he's giving a press conference in the best light for himself. Brosnan's attorney said there was a struggle. Brosnan pulls out the taser, but it doesn't deploy the taser, and that Mr. Brooks takes the taser and uses it against him, against the police officer. The police officer hits the ground. He gets up. He's limping. He's disoriented. What I think is important is from Rolfe's attorney. He is indicating that everything was fine and it became violent when they tried to bring him to the ground. He wouldn't listen to verbal commands. He resisted arrest. He escalated by punching Rolfe in the face, which equals, the lawyer says, obstruction, resisting arrest. Rolfe deploys the taser 2 times, but it's to no effect on the victim. He continues the assault, this is the lawyer saying, by disarming Brosnan's taser, thereby committing a robbery, the use of force, and a theft. And through a crowded parking lot, he's running, and instead of a mere escape, the lawyer says, Brooks reaches back, extends his arms, points an object. This is going to be really important in my mind to their defense. He hears a sound that sounds like a gunshot and a flash. flesh. He's fearing for his safety and other officers. And then the lawyer goes into the deadly force statute of Georgia, which allows you to use deadly force on a suspect that's a felon if they're an immediate threat to the violence of others. So, Lisa, my question is, and many people have asked this, to be fair, as a defense lawyer, are they going to be saying, when he turned around and fired something, the officer hears something that sounds like a shot and sees a flash, he has no idea if it's a taser or a gun? I think that's where they're going.
It is, and I'm going to tell you, in the initial part where they were putting him under arrest and attempting to put handcuffs on him, I don't believe there's any video footage that I've seen that showed that there was a pat-down, because procedure is you need to make sure that they don't have weapons on them. And the cuffing comes first before the pat-down to find out if they have weapons. So were they not aware if he had his own weapon at that point, in addition to the taser that he stole from the police officer? Because it went from 0 to 100 so quickly and within seconds, there are decisions that are made in fight or flight scenarios. So as he ran off, he had the taser, he aimed the taser. They're trying to gain an assessment to defend themselves and to defend their personal body and the public around them. Did they not know that that was a taser being fired at them, or was he able to retrieve a weapon on his person that they were not able to find in the pat-down?
Yeah, I think this is going to be a major case. And again, we're not trying to pass on the rightness or wrongness, but these officers now are entitled to those rights that any defendant is. This, unlike the Floyd case, is an arguable case for the defendants, the police officers in this particular case. And I think those lawyers spelled it out in chapter and verse as to exactly where they're going to go with it. Lisa, great commentary. I really appreciate it. We have a lot more to discuss here on this special report, Keeping the Peace. We'll be right back. Okay, we have breaking news on Rayshard Brooks' case. Both of those officers were arrested. Obviously, Garrett Rolfe's bail is very high because it's felony murder. I believe it was about a $50,000 bail on Devin Brosnan, the other police officer charged with aggravated assault and 2 violations of oath of office. He has bonded out. That's right. Police officer Devin Brosnan is now free on bond, and that certainly will greatly assist the defense attorneys in being able to prepare a case, because it's very difficult to prepare a case when you have your client in jail. So we want to go back to the district attorney who was actually saying that presciently Brosnan is actually a cooperating witness with law enforcement authorities. Let's take a listen.
The Atlanta mayor, Mayor Keisha Bottoms, and the police department concluded that Officer Rolfe's actions were excessive and in violation of APD's SOP. There's an SOP, I believe it's 4.1.1. And after their analysis that the actions were excessive, Officer Rolfe was fired. We have also concluded that Rolfe was aware that the taser in Brooks's possession, that it was fired twice. And once it's fired twice, it presented no danger to him or to any other persons. Now, we have had something quite remarkable to happen in this case, and it involves the testimony of the other officer, Devin Brosnan, because Officer Brosnan has now become a state's witness. He has decided to testify on behalf of the state in this case. What he has said to us, that is within a matter of days, he plans to make a statement regarding the culpability of Officer Rolfe. But he indicated that he is not psychologically willing to give that statement today. Officer Brosnan, however, has admitted that he was in fact standing on Mr. Brooks's body immediately after the shooting.
You know, Lisa, I got to tell you, having give these press conferences, and I know every state's rules are different, but I find it, and I'm sorry, again, I'm just talking as a lawyer here. I find it unseemly that this level of a conference is being done with this level of detail, while we had an obligation to inform the public with regard to charges filed, stages of an investigation. We were always You will hear us in court. You're free to come to court to listen to the arguments being made. He is now indicating that Brosnan, who just, by the way, was a recognizance, we're finding out this new development, bail, so he was released on his own recognizance, is a cooperating witness. He's now discussing the quality of the evidence. The defense lawyers say, no, our client is not a cooperating witness. And this is the reason you don't do these things. You don't battle this out in the court of public opinion. You give basic information. Those who are interested can go to the court proceedings, read affidavits, read the records, and the press can report on it. What are your thoughts about this kind of press conference? Whether it's valid in Georgia to do this or not? Certainly in Jersey, it'd be a problem.
It was premature, and it does taint it in a sense of making the public aware, and then also potential jurors later on, if they are privy to this press conference, that an officer was ready to go against another officer and be a cooperating witness with the state, and then to have it turn out that that's not the case. So extremely premature, and it does create a bias, my belief is.
Yeah, and this is why you try to, I believe me, nothing was more, I do media all the time. Nothing was more pressure than those cameras in your face and people looking to get immediate data, and you got to hold strong to that. Now, like I said, ethics rules are different in each state. In Jersey, it's very, very restricted, so as not to poison the jury pool, not to play it out in the court of public opinion. But let's go to the cooperating witness piece. I'm wondering, as a prosecutor, and I'm thinking about it, what would I use him for? If the lawyer would want a cooperation agreement. In other words, I want my client not to go to jail. I'm not really sure of the basis of these aggravated assault charges and what they really mean. And in exchange for that, we'll cooperate. But what evidence do you think that Brosnan has that he can cooperate with respect to the singular most important issue in the case? When the victim turned around with something in his hand and pointed it at or in the direction of that officer, and a flash, according to the defense lawyers, and a bang went off. What can Brosnan give as far as evidence that would be helpful to the government?
The only thing that I can see him coming forward with is past history, showing up on a call and being a backup officer with him and seeing some type of abuse in the past. But as far as that initial encounter, and the subject was fleeing, and both of them in that moment, we could assume, because of the way that it played out, that they were in fear of their life. I can't see anything different except if they were to go into the history of that officer and see if there was a potential of police corruption or assaults or anything in his record that would show that he was prone to hurting individuals without authority.
Yeah, we just saw that clip again, Lisa. I'm not sure if you had an opportunity to see it, but I know that the district attorney, maybe I'm confused, said that after it's deployed twice, it can't be used again. But you definitely see a flash that's occurring when that object is pointed at or in the direction of the police officer. Anyway, the prosecutor, district attorney, chose to give this press conference. Obviously, it's going to have a reaction by those who are on both cop supporters and those who are not. And one of those was Mr. Brooks' wife. Let's take a listen.
I just want to say thank you, and I just hope that everything falls out how it needs to fall out and these officers are charged. I'm really hurt. Father's Day is coming up, and all I can do is just think about what if my husband was still here.
When you heard some of the details, some of the raw, disturbing details about what happened to Rayshard with a more than 2-minute delay to render life-saving aid, kicking him, stepping on him. When you heard those details, you can only imagine what you were feeling.
Right, I was very hurt. I couldn't imagine being there because I don't know what I would have done if I would have seen that for myself. But I felt everything that he felt just by hearing what he went through. And it hurt. It hurt really bad.
This isn't like a celebration or a victory lap of watching these officers get charged. Nobody's happy, nobody's celebrating, because this never should have happened. We shouldn't have to celebrate as African Americans when we get a piece of justice like today. We shouldn't have to celebrate and parade when an officer is held accountable for actions that we saw and actions that we didn't know about until today.
Okay, Lisa Lockwood. I mean, obviously very emotional for the family, and we all understand that. But let me ask you, based on your significant law enforcement experience, this is what we do as lawyers, right? This is what we learn in law school. You just keep flipping the questions around, asking new questions. Here's my question: had there not been a fatality, had there not been a shooting and a fatality here, would the victim in this case, if they finally captured him, we had a guest on yesterday, made a very good point. You can let him go, you can find them, there's ways of doing that. But if there had not been a fatality, would he have been charged, the victim, with forcible robbery, that is, taking a theft, taking the officer's weapon, the use of force, aggravated assault on a police officer, resisting arrest? Because this happens every day, everywhere, in every state in the country.
Right.
Do you think that happens? And two, if it would have happened, is it all over with simply because the shots were fired allegedly for the wrong reason?
Yes, all the charges that you said, my belief is that would have happened, definitely. He was fleeing, he committed an assault and battery against the police officers, he disarmed the police officer, etc. So the charges would definitely be there. And this would not be a conversation. I wish that that was the case. We all wish that that was the case, that it had went that in that manner. And playing armchair quarterback right now is extremely difficult regarding whether this was justified based on the position the police officers were in that moment. As I said before, it went from 0 to 100. And the thought, in my belief, is the thought in their minds is that this could be a potential death scenario for them or hurting the public around them.
Yeah, and just compare and contrast, and I know it's terrible to do, but much different as far as proofs are concerned from the Floyd case, Mr. Floyd's death. A much different scenario, a much more defensible case in Atlanta. And again, I'm not making commentary. This is a legal analysis. What do you think?
Yeah, police officers are put through no shoot scenarios, whether or not this officer had enough training, because we know over 50 million interactions are done with the police every year with the public across the United States. 1,000 are shooting cases. Of those 1,000, 30 to 50 of those cases are unarmed people.
Okay.
And then of that,
Lisa,
there are bad shoots.
Lisa, I got to cut you off. I'm sorry. We got to go back to our regularly scheduled program. Thanks so much for watching our show.